Imagine walking out of a store, your thoughts preoccupied, perhaps with a phone call or a child's tantrum, only to realize later that an item you intended to purchase was still in your cart or bag, unpaid. It is a common scenario, and it can happen to anyone. But what happens then? Could you actually face legal trouble for something that was purely an accident, a genuine oversight? Yes, you absolutely can be charged with shoplifting even if you did not consciously intend to steal the item. While intent is often a crucial element in criminal cases, many jurisdictions define shoplifting in a way that allows for charges based on the act itself, rather than requiring explicit proof of a deliberate plan to deprive the store of its property. This might seem counterintuitive because we often associate crime with a guilty mind, or what is legally termed mens rea. However, shoplifting statutes, especially at the state level, can be quite broad. Some laws focus on the actus reus, or the guilty act, such as the concealment of merchandise or removing it from the premises without paying. In these situations, the prosecutor may only need to prove that you committed the act, and your intent can be inferred from your actions. For instance, deliberately concealing an item, even if you plan to pay for it later, could be interpreted as an act consistent with an intent to steal, depending on the specific state law and the circumstances. The burden often shifts to you to demonstrate that your actions were truly accidental, which can be challenging without proper legal representation. If you find yourself in such a situation, it is important to remain calm and remember your rights. Do not resist any store personnel or law enforcement officers. You should politely decline to answer questions without a lawyer present. Providing explanations or apologies can inadvertently be used against you as an admission of guilt. Immediately seek legal counsel. An attorney can help you understand the specific charges under your state's laws and develop a defense strategy, which might involve presenting evidence of your lack of criminal intent, such as proof of your ability to pay, other items you purchased, or the sheer value of the item in question. Understanding the subtle legal distinctions can make a big difference. Many state laws include merchant protection statutes that grant stores certain rights in detaining suspected shoplifters and presume intent based on actions like concealment. This means that while a specific intent to permanently deprive the merchant of property might not always need to be proven explicitly, actions like altering price tags or passing all points of sale with unpaid merchandise can create a legal presumption of intent. Another critical term is willful concealment, where merely hiding an item, even if not yet past the checkout, can sometimes constitute shoplifting in certain states, regardless of the ultimate intent to pay. So, while your heart might be in the right place, a simple mistake or misunderstanding can indeed lead to serious shoplifting charges. Navigating these legal waters requires a clear understanding of your state's specific laws and the role intent plays within them. The overall benefit of knowing this is to protect yourself proactively by being aware of how your actions might be interpreted and, crucially, to always have legal guidance if you ever face such an accusation, ensuring your rights and reputation are safeguarded.